The following is a project of our nonprofit newsroom. Support Midcoast Morning and local journalism today at chly.ca/donate. Local news doesn't survive without local support.
Hello and welcome to Midcoast Morning. I'm Joe Pugh. A former MLA and current negotiator for the Tsarlip First Nation says a court decision around Cowichan title is not an outlier, but part of a legal trajectory the Crown has been warned about for decades. Earlier this month, a BC Supreme Court decision recognized the Cowichan tribe's title on a section of lands south of the Fraser River. Justice Barbara Young outlined her reasoning in an 863-page decision, and the trial began more than 5 years ago. BC's Attorney General Nikki Sharma has announced the provincial government's intention to appeal the decision. Adam Olsen spent 7 years in the legislature as the MLA for Saanich North and the Islands. He addressed the case in an article that appeared in the Tyee this week. I spoke with him about his perspective on it.
Rachel, good day. My name is Tsahanap. Adam Olsen is my English name. Tsahanap is my straight Salish, Coast Salish name. I'm from CHLY, the Tsarlip community, and I currently work in the community here as a negotiator with the different Crown governments. And formerly, I was the MLA for Saanich North and the Islands up until the last election, and so I've spent the last 7 or so years in the legislature, so I guess 8 years now. But it's been almost a year since I've retired, so there we are. So that's me.
Well, welcome to the program. Thank you very much for making some time. You called the recent decision around Cowichan title on land south of the Fraser River the predictable result of generations of political inaction. Can you tell me more about what you mean?
Yeah, I think that it's pretty clear that the Canadian judicial branch, the courts, have been asking of the legislative and executive branches of government to negotiate Aboriginal title. And I think that the reason for writing that piece is because there's this narrative that comes out of the government talking about unforeseeable consequences of this decision, this Cowichan tribes versus Canada decision. And in actual fact, none of it was unforeseeable. All of it was entirely right before us, and the courts starting in Calder, but mostly Dalgamuch on to Haida and throughout have been saying to the legislative and executive branches of government, the government, you need to negotiate Aboriginal title because litigating is going to be very expensive. It's very confrontational, and the path that we're on is we are going to continue to identify Aboriginal title, probably in most places that First Nations are going to ask, because we've had this land question hanging over us since the very Confederation. The forefathers, the legislative forefathers in this province, didn't do the work that they needed to do in order to settle the land question through treaty or through purchase. Vast majority of British Columbia, most if not all of British Columbia, is implicated in that. And I think what we see is now the courts continuing on the path that they've been on. And I think that that's what's important to acknowledge here, is that this is likely, because of the way that our court system is set up, this is the path that they're going to continue to go on. So it becomes even more important for political action to get to that point. It's the result of political inaction, the way that we resolve this situation so that we can all live together in peace, like we want to live in peace in our territory, and so that we can all live together like that is collaboratively, is to have the government take political action on this issue.
Now, in the wake of the decision, Premier David Eby said that owning private property with clear title is key to borrowing for a mortgage, economic certainty, and the real estate market. He also said that we remain committed to protecting and upholding this foundation of business and personal predictability, and our provincial economy for Indigenous and non-Indigenous people alike. What do you make of the implications of those statements as they relate to this case?
Well, I think that it's important to acknowledge that he's right. He's correct in the statement that he's making. But what he's not saying is what's important here. And that is that Aboriginal title in this case, and the courts have been alluding to over decades, but this Cowichan tribes case begins to lay totally bare and in the plain view of the public and of the government, is that Aboriginal title lies beyond that system. So that system is built on top of Aboriginal title, if you want to put it that way. So the Premier can talk and wax eloquent all he wants about that. This question that we're talking about is beyond that piece. And that's why it's really incumbent upon the governments, especially the ones that lie in between Aboriginal title and where we're at, to sit down to listen to the court system and to sit down and negotiate, create tables that are effectively negotiating a pathway forward, like we did with the Haida Nation Recognition Amendment Act. And I think this is what's really important about this that British Columbians need to understand, is that where the government is motivated to negotiate title, they've proven willing and able to do it. And I think our courts are going to look at that and say, look, it is inappropriate after showing us that you can actually relieve private property owners of this tension through a negotiated settlement with First Nations. We want you to continue on that path, because the toxicity of continuing down the litigation path is way too high from a societal perspective. It's just it's morally incorrect. And so it's David Eby can talk about the importance of the structures that we set up in this province for private property rights. But what this court found was that the Aboriginal title is beyond that piece. And so he and his Attorney General and his Minister responsible for lands need to be very careful about how they continue to go forward. And I would suggest that part of the work that they need to do is educating the public and spending quite a bit of time articulating what the history of this province is, because that's what we're coming into a collision with here. And that is a general misunderstanding, broad misunderstanding across society about actually how settled the land question in this province was. And it's something that I talked about for 7 years in the legislature. So that's the reason why when the Minister, Attorney General, says that it's surprising, that, it's not surprising. The legislature's been aware of this at least since I was an MLA, because I talked about it often, saying that this is our primary job to settle these questions and to make sure that British Columbia can move forward. First, Crown Indigenous Crown relations can move forward together so that we can accomplish the things that we need to accomplish, because the way that it has been set up till now is unlikely to continue going forward. So we have to figure that out.
Why do you think this particular case has made its way through the courts in contrast to what happened with the agreement on Haida title?
Well, I think that, as the media has done a good job of outlining, this, I think it started in it's one of the longest court cases, I think the longest court case or something like that. So it started in 2019. There was pre-trial rulings in 2017. So this case has been, as these cases are, very expensive, very exhaustive, tons of research put in behind it. The Cowichan had to prove their use of that space, and the court had to be satisfied with it. And, I think that's obviously what came of that, the BC Supreme Court. So this case has always been lingering. The decision on this case has been lingering. And at some point in 2019 or before 2019, the Crown decided to let this case go to trial rather than continuing to pursue negotiated outcomes. And so it went into the litigation process. And, once that starts, it's really, it then becomes, both sides then become entrenched in that litigation process. And, we passed the Declaration Act, which is, a legislative tool that's supposed to help us through this by acknowledging and fully recognizing the breadth of belonging that Indigenous people have to these places in British Columbia, around British Columbia. The Declaration Act is supposed to be a declaration of acknowledgement of that and us moving forward together in a good way through negotiation rather than through the more combative litigative process. And then there was a government and perhaps a cabinet minister in Murray Rankin that was specifically motivated to with a Haida case looming over top of, in a very similar situation we were in 2019 with the Cowichan case looming over us. Haida also has a case that is going to be heard by the Supreme Court, and I think that the Crowns decided at that time in 2024 last year that they were going to get out in front of that and start the process of negotiating. Despite the litigation route that the Cowichan case took, we've seen that the Haida title or the Haida Nation Recognition Act process in a parallel to what was going on in the courts. What's interesting is the way that the provincial government responded. They immediately came out with the kind of narratives and rhetoric that you talked about. Nikki Sharma had her own special forms of rhetoric talking about unintended consequences, which was a key part of the piece that I wrote in the Tyee. They talked about protecting private property rights, like First Nations and Indigenous Aboriginal rights are the threat to private property rights. It's not. It's a government who's unwilling to sit down at the table and negotiate resolution to these very complex but and old but relevant legal questions that need to be answered. And that if it was anybody other than First Nations, they would expect them to be answered as well. And I would say that if David Eby actually believes what he says, in his political rhetoric, which is that this is stability in this situation is a foundation to our economy, et cetera, then he'll be negotiating, like with Cowichan and with other First Nations. He'll set up an effective process, one that we can count on, one that's properly funded, and we'll start to resolve the land question that's hung over us, so we can, in fact, all benefit from that system.
Now, you spent 7 years as an MLA in Victoria. I know you weren't a member of the governing NDP party, but during that time, from that perspective, can you tell me about what you saw in terms of inside government negotiations with First Nations?
Well, I wasn't part of the governing party, but I was one of 3 Green MLAs that signed a confidence and supply agreement that installed the BC NDP into government. They are there because of that CASA, Confidence and Supply Agreement, that we signed in 2017. A big part of that Confidence and Supply Agreement was the Declaration Act, and I, as in the BC Green Caucus, was the lead on that file, and became it was the issue that needed to be advanced from my perspective by that government in order to continue to have our confidence, because we've been warned by the courts to deal with this through that process. So what I can say is, I think that the BC NDP government absolutely had the right idea to move us in this direction, to listen to the courts, to heed their warnings, to heed their advice, and to begin the process of creating and establishing a place for negotiation. There's a table that I'm a part of right now. It's not a particularly effective table yet, but the Crowns can make it an effective table. They're called Recognition of Indigenous Rights and Self-Determination tables. And these are exactly a place for a negotiated resolution to the land question that we have. The idea of it is to recognize, it's based on a basic recognition of rights, but the goal of it is to create self-reliance and self-determination for First Nations. And, I think as a society, that's a very important goal for us to set, and a very important program for us to be accomplished in. But what I've witnessed is a government that has understood reconciliation for its political rhetoric, but not understood how to implement reconciliation once they got the principles in place and the values in place. They didn't have a plan or didn't know how to implement it. And so what we see is it becomes very fragile to these to political winds and shifts. And this isn't political. This is legal. And I think that that's one of the key things that, like scrambling to take the same position as the opposition, which is what Nikki Sharma and the BC NDP did. They got out in front of the BC Conservatives, which were going to say, protect private property rights, right? And so they all scrambled to the same position in the legislature when what they should have said is, look, there's some questions about this that we're going to ask the Supreme Court to look at maybe, but we are going to double down on a negotiative route. We're going to create effective tables, ones that move forward to resolution, not because because we know that this is the path. And that is not the approach that they took. So we need a government that is seized with implementing the Declaration Act, the action plan, with some urgency, but with thoughtfulness and in collaboration with First Nations leaders. Those tables need to be funded. They need to be accessible, and we need to be looking at creating models on the back end of it that allow for First Nations governments and First Nations communities to be self-reliant on revenues, because that Aboriginal title exists and it's a real thing. It's not fake. And because First Nations communities deserve to have the amount of resources they need in order to run a government and to look after their members.
On this particular Cowichan title decision, in a press release, the Musqueam Nation called it a devastating decision impacting Musqueam's Aboriginal title and fishing rights. What do you make of that side of this issue?
Yeah, so in one of the things that we've long understood is that the way that the map looks today is not the way that the map was when those first boats showed up. The way that we, for Indigenous people on the coast here, were governed, our relationships between communities, really relationships between families, intermarriages, how our economy worked, how these spaces are organized today are in no way similar to the way that the spaces were organized in the past. And a couple of key things happened. Multiple things happened, but I think disease had a key role in that. But then as well, the Indian Act in creating Indian reserves, which basically started to enshrine a crown construct over the map, over the geography, right? And so, and then the BC Treaty process and the maps that were created through that process did further entrench that and did the same. So I'm describing it this way because I think it's important to acknowledge that through the conversation of the Crown constructs of land and geography and boundary lines and the lines that they've asked First Nations to draw around their treaties, around their territories, it's a manufactured construct. And so what we have more than 100% of the province is claimed, right? So okay, how does that happen? Well, through the Crown policy, that's how that happens. It was created that way. The provincial government, to their credit, know that this is a big problem. They've been experiencing the ill effects of this system that they created. And that's why in the Declaration Act Action Plan 1.1 is direction to solve this problem, to create a structure or to create an entity that can help the government and First Nations resolve the boundary and the shared territory issues and the overlaps that have been in the past. There was a governing structure in place that allowed for First Nations to be able to resolve that. And now the governing structure that's been imposed on top of that through a Crown lens has been not effective in solving that issue. In fact, it's leveraged those border disagreements. The Crowns have leveraged it for their own benefit for decades, and First Nations have experienced that. So, I think the minister, Spencer Shander Herbert, has and the former minister, Christine Boyle, before the cabinet shuffle that happened earlier this year, both of those ministers have in their mandate letters, of the 5 or 6 things the premier mentions in that are specific to the Ministry of Indigenous Relations and Reconciliation portfolio, consistent over 2 ministers, is deal with this issue. So the premier and the government knows that we're going to continue to get this because First Nations have to defend themselves in these processes, and First Nations have to defend themselves through the system that's been created for it. So the Cowichan are using the legal system, the Canadian legal system, to get a decision on this question that they have about these lands in the Lower Mainland, and the Musqueam are using that system and arguments that are available to them in that system, because they're also forced to play in or to work in that and on that landscape. So I think it's not surprising that, and you will see that wherever there are these overlapping areas, we're in the process right now from a treaty perspective to in a consultation process to deal with what the province claims to be overlapping territories. And I've said, I think that the way that you see the world, the way that you see the geography, and the way that we see the geography might be slightly different. But you've created this BC treaty process. We've created these legislations that have set these boundaries, and now we're forced to defend ourselves within that. And so it's very unfortunate, because most of those border areas that we see of First Nations, there is a lot of families that are connected to both sides of that border. Like, there's a lot of mix between us and our relatives in Songhees, for an example, in Victoria, and north in Cowichan. I've got lots of cousins in Cowichan. I'm Saanich, they're Cowichan, right? The Indian reserves have these hard boundaries. I'm a member here, they're a member there. Our chief is responsible for the members here. Their chiefs are responsible for the members there. And we then, the social reality is that there's the cultural pieces that can be used to resolve those social questions, but the governance and the political questions, First Nations are really forced to answer those, or to engage with those right now through the Crown mechanisms that have been set up, through the legislation, and through the legal system that has been set up over top of the whole land base.
In that statement, Musqueam also said that it's saddened that the Cowichan tribes use the colonial system against traditional Coast Salish ways of intercommunity governing. The statement said the outcome of the case does not resolve our differences and does not reflect our teachings. What do you make of that? Like, is there any kind of alternative system that could be used?
Well, this is exactly, yeah. Yeah, there is. They could have done the 1.1. We could already have a system in place that is dealing with these boundaries. The provincial government has been, when was the action plan brought in 2021? It's now 2024, right? So, and does it resolve the Cowichan piece? No, I mean, the Cowichan piece has been coming from 2019, since before the Declaration Act legislation was passed. And I'm not going to the Cowichan and the Musqueam will have their political and their cultural discussions, but ultimately the Crown systems that have been imposed upon this issue are adding and exacerbating the issue and making it a lot more challenging. And so the Crowns do have a very important role to play in this, and we now have 175 years of history that has happened, and that all of the processes have been going through the Indian Act and through these other legislative processes, and so it's deeply entrenched, and it forces the litigation process forces us to make some really, really, really tough decisions, absolutely really tough decisions about which cases that get moved forward, how to address your relatives that are on the other side of that case. It is exceptionally challenging decision making for our leaders. Absolutely.
Now, obviously, there's still going to be an appeal on this. There's the potential for the decision to be stayed in the meantime. But one of the results of this is that the government has been ordered to negotiate in good faith. They've been given a window of 18 months to start that negotiation. How do you think a negotiation that is kind of imposed by the court system would differ from the kind of other treaty processes that are ongoing in BC right now?
Well, there is a choice that I think the government has, and that is certainty or uncertainty. And I think the reality is that certainty can be negotiated. Uncertainty comes from leaving it to the courts. Even though I'm suggesting that, even though I believe that we have long seen these decisions about title coming. Chilcotin, CHLY, Cowichan, right? Negotiated Haida. So we're seeing multiple examples of this legal and governance systems. And even though I'm suggesting that, we could foresee this coming, there is an aspect of uncertainty that exists here. And I think that it's the uncertainty that is creating a lot of the fear that people have. And so, I really think that the provincial government, federal government need to take this as a sign that the justice system is on the path that it is on. And that because it is set up the way it is, it's likely to continue down that path. Maybe not entirely with what this decision is, but there's a lot in this decision. There's a lot we're not talking about in this decision because I haven't even got through and understood all of the nuances of it yet, and neither of you, and we haven't. But it's nuanced. There's layers. This judge layer and layer and layer of it on this, and all of these questions that in my article I go back to 1877, and I think that it's really important for the public to understand this. There was a public and political awareness that this land question needed to be answered, and that the cost of this question was too great at that point to deal with, and was going to be even greater if First Nations decided to press this question at some point in the future. Right? And so 1877 was when there was an article written, and I quoted that in my Tyee article because I wanted to provide that context. That for all of these years, our governments have been dithering, even though that they've understood, they've forced these questions to the courts. The only way, and it's like, why is the Cowichan forced to take this to the court and not resolve this question elsewhere? Is because when you go and sit with the Crown in these negotiation tables, they delay, they deny, they detract, and they deflect constantly, all the time. And it's like, unless they are compelled to do something, and usually that's through the threat of litigation or some kind of act of civil disobedience, there is no fire at that table from the Crown's perspective. And so you sit there in these tables, spinning your wheels and having them go absolutely nowhere. And so in order for you to be a responsible governor of your community, you have to make a decision. We're not getting, there's nothing behind the Crown's so-called desire to negotiate here. We're not seeing anything. They're not bringing anything to the table. There's no ideas. Everything that we put on the table, they're resisting. They deny, they deflect, they detract, right? All of these are feelings that First Nations communities get at these tables. So the key difference would be, of course, continue with the tables, but have them enable them to actually come to resolution. And I think the key to this is really important to point out is it ends up being political, right? Because the Crown doesn't want to give up any of the power, authority, or decision-making that it has. It wants to have reconciliation without actually having to move any inches. And I think that that's ultimately what they hold on to. Is like, can we deliver reconciliation without actually changing anything? And I think the reality of that question is no, things will change. And so let's do that. Let's create that change together in a collaborative way, because guess what? My entire experience is that the First Nations people that I work around love the places that they live in. They love their territories. They want to look after those places, and they want those places to be good for everybody, for nature, for everybody that lives there. Like these are just general feelings that from the conversations that I get. And so let's have those conversations, because the quality of our communities are really what at stake here. Like we could have even greater communities than the ones that we live in if they were collaborative, and if there wasn't this decades old question that is just lingering above us all, and the reality of answering it is so much more exciting than continuing to fight it out in court. Like that's just so it's depressing. Frankly, it's embarrassing. We shouldn't be doing that. We should be embracing the exciting opportunity of working our way through this. And it's going to be slightly different for First Nations around the province, but having negotiating tables that are inspired to do that. And so you ask, like, a really long-winded way of answering this question, but you ask, what's going to inspire the government to be there different? I don't know. We saw a differently inspired government when the BC Supreme Court Justice did the same thing in the Blueberry, the Yahé case, that talked about cumulative effects. And, this was the judge back in 2021 or 3. You'll have to fact check me on that. But the decision was no more oil and gas permits until you guys figure it out. Right? And the government was sufficiently motivated by the oil and gas industry to resolve that situation. So they didn't even appeal it to the Supreme Court of Canada. They accepted the case and they negotiated an outcome with the Blueberry. Now, was that a perfect outcome? Far, 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 far from it. But we can learn from that process. We can improve that process. We can be more collaborative in creating a process that works for not only the First Nation that wins the case, but the First Nations around them, like the relationship between Cowichan and Musqueam. We can be a lot more inclusive in that if we design a process that does that. And the courts don't do that. It's one against the other. It's this or that. And so, I'm much more excited about the opportunities that this creates for us to finally overcome this land question, get beyond it, so that we're beyond that title question together, and we can move forward and create a society that isn't got this legal divide in it, this unresolved legal divide in it, because we've got together and found a way to resolve it.
Just before I let you go, one last thing I wanted to make sure to ask. Given everything you've said about the lay of the land you feel in the court system right now and the way things are headed and what the precedent seems to say, what do you make of the move to appeal this decision, and what do you think is going to come from that ultimately?
Well, I think that partly it was politically motivated. I talked about that earlier. I mean, I think the BC NDP were responding to the media narrative that started almost immediately, the public narrative that started almost immediately, which is this is a threat to private property rights. And I appreciate this question because it allows me to repeat something that I've said very often, and that is that actually, and it's at the heart of this piece that I wrote, and that is that it's not like the threat to private property rights. It says it right in the title. The threat to private property rights isn't Aboriginal title. It's a reality that we have to deal with. The threat to private property rights is a government that's unwilling to face that reality and actually deal with it. Continuing to do it continues to put questions on the land management system that is created here, even though we know that Aboriginal title is above that or beyond that. So I think that the opportunity that we face right now is to create some alignment here, and that First Nations are going to have to be a key piece of that. and they're going to be key players in their territory, just as it should be, and in our territories, in our communities. And I think this threat to private property rights, the provincial government decided to run out and say, we're going to appeal this. Did it right away before the BC Conservatives could come out and say, you got to, there's this, your project on reconciliation is a massive threat to private property rights. It's not. It's leaving these questions unresolved that is the biggest threat in our society right now. And as we see in Haida Gwaii, the private property owners in Haida Gwaii have their land question resolved, and now it's a relationship with Haida and a governing body that governs that place, and it has agreements to govern it in partnership with the provincial government, and the people there have their private property rights clarified. Those questions have been clarified for them, and I think that British Columbians, First Nations, non-First Nations deserve to have those questions clarified for them. I don't disagree with the Premier that it is that urgent, but the remedy is not through the courts. And I think the Premier knows that the remedy is not through the courts. The remedy is through good faith discussions at the table. And so the only body in this province that can create the framework and the platform for those good faith discussions, the only group that has the resources to do it is the provincial and federal governments. And so it is incumbent upon them to create those systems that are effective, that are efficient, and that don't rely on appeals. It will take a while. This question will remain unresolved. The question will linger. I think the governments need to take that 18 months that the courts have given them, and they need to make the best of it, both for Cowichan, Musqueam, Tsawwassen, and all the other First Nations in the area. But they need to use that as an example and as a template for other discussions around the province, because it's more than just in the Lower Mainland. It's everywhere. It's here in Greater Victoria. It's all across this province. BC is an outlier. We need to admit that we're an outlier, and we need to get on with growing up in this province.
Adam Olsen, thank you so much for taking the time to speak with me.
Thank you for the opportunity.
Adam Olsen is a former MLA for North Saanich and the Islands and a negotiator with the Tsarlip First Nation. That's our show for the day. Thank you for joining me. I'm Joe Pugh, host and producer of Midcoast Morning. Jesse Woodward is our executive producer, and Arby Frew is our technical advisor. Our theme song is First One by local Nanaimo band Waste Management. If you have a story you'd like us to cover, email us at news@chly.ca. That's all for now. I'll talk to you on another Midcoast Morning.
This program gives thanks to the Snuneymuxw First Nation as we broadcast and podcast from their traditional territory. Thanks for listening.